say the card, please? The Honorable Supreme Court of the State of New Mexico.
Morning. May be seated. Thank you. We're on the record at S-1-SC-40411, Pena versus Naranjo. May I have Helen will enter appearance. You have 25 minutes.
Good morning and thank you, Chief Justice Thompson. My name is Coach Rogers and I, along with my co-counsel Blake Allen, represent Rio Arriba County Commission Chair Alex Naranjo, who's also here in court with us today. It is very easy in litigation to develop tunnel vision. You're scrutinizing every single tree. You lose sight of the fact that you're actually in a forest. Particularly in the context of a case like this, which is set up to sort of hurtle towards this evidentiary proceeding. We can get very in the weeds on specific issues of proof and evidence. And so I appreciate the opportunity that the court gave us with its order to look at the Paragon Foundation case to sort of go back up to 35,000 feet and look at this from a different perspective or with a fresh set of eyes. I want to address that case because I think it's dispositive in many ways with regard to the issues before this court. In that case, the district court held that there was no Open Meetings Act violation because the Open Meetings Act didn't apply. The executive director of the Livestock Board had entered into a memorandum of understanding or an MOU with his counterpart at the U.S. Forest Service. There was a lawsuit filed by the landowner whose cattle were, I guess, the subject of that MOU. They filed a suit claiming that the board violated the Open Meetings Act because that MOU was executed outside of a public meeting and by the executive director with no board approval. Everybody agreed in that case that the board took no action. There was no dispute as to that particular fact. The district court denied the request that the landowners had filed for injunctive relief and then ultimately granted the board's motion for summary judgment on the Open Meetings Act issue. The Court of Appeals affirmed that decision, and they started their analysis by looking at the plain language of the Open Meetings Act. Section 10-15-1A says that all meetings of any public body, except the legislature and the courts, are subject to the Open Meetings Act. The very next paragraph, section 10-15-1B, says that all meetings of a quorum of members of any board, commission, it lists several different legal entities, that are held for the purpose of formulating public policy are public meetings for purposes of the act. In reading those two sections together, the Court of Appeals said, leads you to sort of this inevitable conclusion that the Open Meetings Act only applies to a quorum of the members of a public body who engage in a meeting. And they said as much at paragraph 13 of that case, where they said, if a quorum of the board members did not act on the memorandum of understanding, the Open Meetings Act was inapplicable, there was no Open Meetings Act violation, and summary judgment was proper. Now, the plaintiffs in that particular instance had sort of an alternative argument that the executive director acted without the approval of the board quorum and that in and of itself was an Open Meetings Act violation. The court said, well, obviously we didn't have a valid action here because he did act outside of his scope of authority, outside of any authority that was given to him by the board. So we didn't have a legally valid action, but we also didn't have an Open Meetings Act violation because we didn't have a board action. We had no action by a quorum of the board members of that board. And so for that reason, it was not an Open Meetings Act violation, although it very well may have been an act that had no legal effect. Court of Appeals said you can't have it both ways. You can't argue that the memorandum itself was a board action and then also argue that the executive director didn't have the authority to take that action. And the facts here are very similar to that case. And the petitioner's argument suffers from the same fatal flaws as the Paragon Foundation petitioners. If a quorum of the Rio Arriba County Commission did not act in this case, then there is no application.
Is it a question of whether they didn't act or the trial court did not find they did not act? There is some question goes to that and sort of our review of the trial court findings. Trial court does not seem to conclude that it was a quorum of the county commissioner outside of an open meeting, that it was an individual, but there are facts. I think some of the emails canceling the installation indicate we as a collective, meaning it could have been the county commission as a quorum. What do we do? So is this a matter of reviewing the trial court's findings? And do we have the ability to do that?
Yes, to your latter question, Chief Justice, and it's both is what it is in this particular instance. The trial court erred in its determination that Commissioner Naranjo alone took an action that violated the Open Meetings Act. And that's because he can't have done so under the case law. Under Paragon Foundation.
But is that really what the trial court found? I mean, the trial court can say two of three, their mind, that's a quorum, and still only address the action of the individual that's in front of them. I'm not sure the trial court here said that the commissioner acted alone, as opposed to was part of a quorum and therefore I don't have to say both of you have violated the Open Meetings Act because both of them are subject to the suit. It's only the one that's quote unquote in trouble, to use, a shortcut type of term.
I would answer that in two ways, Justice Bacon. One is that the record is devoid of any evidence by any board of county commissioners' action related to this statute at any time ever.
But what about the emails talking about the commission has approved, the commission has instructed, the commission, the emails from Mr. Meiosis referred to the commission.
They do, Judge.
Is that not sufficient to satisfy?
It's not, because the Board of County Commissioners, when it is acting in a lawful manner, and Justice Bacon is exactly correct that for a 3-member board, that requires two members as a quorum. For it to have done so legally, it has to generate minutes. And the minutes are the official record of what a public body does. And we know that from Village of Angel Fire versus Wheeler and before.
So if there aren't any minutes, so they do something in secret, it can't be a violation of the Open Meetings Act. That I don't think that's the law.
It can't be an official act, Justice Bacon. That's what it can't be. And that's what we don't have here. And the district court didn't find
But
that.
the Open Meetings Act is not just limited to official acts. It's discussing public business.
But where there is no quorum and no action by a quorum, the Open Meetings Act does not apply.
But you're now layering on. You're saying there was no official act because there are no minutes. That's a different line of inquiry than whether there was a quorum or not, because two individuals on a board can meet in secret, direct the executive director to do something. And I don't think you would, we certainly can't write an opinion that says, and that's not an Open Meetings Act because it's not official. I mean, that's the logic of where you just went.
Absolutely correct on your analogy and on your example. That would implicate the Open Meetings Act. What we don't have here, we have two levels of failure. We have a legal fallacy, which is this idea that Commissioner Naranjo somehow acting alone could violate the Open Meetings Act. And we also have a failure of proof on two elements. One is that Commissioner Naranjo ever took any action with regard to the statute. There's no evidence, and certainly none that rises to the level of probable cause.
What about Justice Vargas's questions regarding the emails and the meeting minutes from August 29th, 2023 that read in relevant part, we will be erecting the Oñate statue. We would like to have that done within the next 30 days. So those two things coupled together, why isn't that sufficient evidence that the commission acted?
Two reasons, Justice Zamora. The first is that the district court, for whatever reason, disregarded the testimony of the county manager who testified at the hearing that.
But we don't get to look. She found him incredible.
Right.
And that is magic trial court language. Have
Agreed.
used it. I know that the chief used it as a trial court judge to say, this person was not telling the truth
Agreed.
and we can't look behind that.
No, but you also can't then rely on parts of his testimony or parts of the evidence that the trial court didn't rely on in reaching.
So we're
its
supposed to
conclusion.
disregard his emails because,
The trial court found that his evidence was incredible and did not base
Well, that
its
was his
determination.
testimony
she
as
found,
opposed to his written
she
document.
found that the emails were the more likely scenario than what he reported when he testified.
Well, she didn't though, because she didn't find that the commission acted. She made no such finding. There's no finding in the record indicating that the commission took any action. What she found was that Commissioner Naranjo, acting independently, made a decision about the statute. And that's why the Open Meetings Act doesn't apply. And Commissioner Naranjo, acting independently without a quorum of the board, cannot have violated the Open Meetings Act. And that brings us to sort of the error as it is compounded by the fact that that's the only finding that the district court made with regard to Commissioner Naranjo, particularly when it was investigating the corrupt or improper motive prong of the Recall Act. And the definitions are set forth for misfeasance and malfeasance in the act itself. But they both require, particularly when you're dealing with discretionary acts, which disposal of a piece of property certainly would be.
But complying, yeah, go ahead.
No.
Complying with the Open Meetings Act is not discretionary.
But disposal of a piece of property is, Justice Vargas.
But she found that he violated the Open Meetings Act, not that he improperly disposed of public property.
Right, exactly correct. And that's the problem.
Okay.
So the problem is that she didn't find that he made a bad decision with regard to what to do with the statute, or that she didn't agree with his decision. She found that by making that decision outside the scope of an open meeting, that he violated the Open Meetings Act. Well, we know that's a legal fallacy. Under Paragon Foundation, he cannot do that. He can't
Let me-
violate the Open
Let me
Meetings Act.
ask you
by
this.
itself.
I think we're struggling with reconciling some of the findings and some of the testimony because it kind of goes back and forth between talking about the commission and talking about Commissioner Naranjo. Is there any, should we be thinking about whether to remand this to Judge Ward to be more clear in what she was finding when she issued her findings and conclusions?
I think she was very clear in what she found, Justice Vargas, because she was never presented with an argument or with any evidence that the board took any action. That argument appeared for the first time in the petitioner's briefs before this court. That was never presented in the complaint, not in the amended complaint. The only allegations that the district court was asked to look into was, did Commissioner Naranjo, acting alone, make a decision about the statute?
But that's
She
simply
was never
because how,
asked.
that's because of how the matter was pled.
Correct.
The plaintiff chose to plead. For some reason, he picked on Commissioner Naranjo and chose to plead it the way that he did. So the court would maybe not necessarily be focusing on the commission and what the commission did. But we're struggling with the evidence that we have which the emails refer to the commission. The findings refer to Commissioner Naranjo. Should we remand to Judge Ward to ask her to explain what she meant?
I think it's helpful to think about this in the context that it's before us, which is not a sort of a typical civil litigation posture. This is a Recall Act case. And so the choice is to recall a particular elected official. And that's the petition that was filed, the allegations that were made, and the findings that the petitioner asked the district court to make.
And they carried the burden of proof.
Correct. And so the problem only arose before this court when they realized, oh shoot, we need a board action to support an Open Meetings Act violation, because that's the only violation that the district court found. I'm sorry, I didn't mean to interrupt you, Chief Justice.
No, I was going to interrupt you, so that stopped, but,
Feel free.
I guess I do have a question regarding the standard, and as Justice Vargas mentioned, in the probable cause standard in terms of what the trial court was guided by. Probable cause standard, in my mind, is a criminal in terms of, you mentioned that we're dealing with a civil, and what is the burden or the probable cause in a recall petition?
I think that, and there's precious little guidance on that in the law, Judge Aragon. I think that we can lean on those criminal cases and lean on even some of the civil cases that involve a probable cause standard, like in a malicious abuse of process context, or some of the other civil rights type contexts where we deal with probable cause, and it's more likely than not. But again, we have to remember what the district court found here. Not that it was more likely than not that the board did anything. It was more likely than not that Commissioner Naranjo acting alone.
But the evidence that she relied on does reference the commission as opposed to just Commissioner Naranjo. And it gets back to Justice Vargas's question about the emails, which reference the commission and the meeting minutes from August 29th that say we will be erecting and we will like to have this done in the next 30 days. Like collectively, the evidence that really doesn't favor your client is referring to the commission. I'm just wondering how you deal with that. That it's in the record. It's what she relied on. Granted, the findings weren't as clear as they should have been, but in the end, all of that talks about the commission's actions.
I think the problem with relying too heavily on that evidence as it pertains to the commission, Justice Zamora, is that it doesn't rise to that probable cause level. It does not rise to the more likely than not level. For example, we have none of the basic, things you learn in 7th grade are the who, what, where, when, whys. There's no record evidence about who made the decision on the commission. There's no evidence about when that decision was made. There's no evidence about what decision was made. There's just the record's devoid of any evidence to support a finding that the Board of County Commissioners acted here.
And I mean, similar to Aragon, there was some evidence that another commissioner was involved in the decision. But I want to get back to just Vargas's question because, if there's a rule to write here, it seems to be a large burden on the petitioner. They're alleging, they have a petition for recall. They're alleging malfeasance in office, which is in essence the purpose behind that act. They don't necessarily plead it correctly because they allege an individual rather than the body. So is that a failure in pleading? Is this a burden you're putting on the petitioner? Is it a failure in proof at the point of the petitioner obligation to show the legal correctness of a violation of OMA? Where does this burden fall? And why can't a district court take that evidence and correct as a matter of law what is required under the Recall Act? Setting aside, I totally accept the point, which is her findings are findings and they don't indicate a violation by the board.
I think that pleading requirement and those burdens of proof are a feature, not a bug of the Recall Act. And I think that because in New Mexico, we only have recall for cause. We do not have recall at will. The idea is not that anybody can be recalled. Those disputes about sort of lesser issues of political disagreements are solved at the ballot box, not in the courtroom. And so I think that that's intentional. I think the burden is on the petitioner not only to plead appropriately in a manner that would satisfy the elements of the Recall Act, but also to prove those elements. And that's the problem we have here. Without an Open Meetings Act violation, there's nothing else that the district court found that Commissioner Naranjo did that would support a recall effort. So absent that finding and even with that finding and the issues related to the improper or corrupt motive, to which there was absolutely no evidence. The record is devoid of evidence of motive.
Let's circle back to that. Tell me why that is required in a violation of OMA. It is a non-discretionary act. So explain to me again why. Are you alleging if an OMA violation is the basis of a recall petition, in addition, there must be some showing of an improper motive to violate OMA? Because it delineates those acts that require that sort of what I would describe as specific intent.
Sure. And I think, again, we have to look at what was the district court focused on. And the district court was focused on, okay, Commissioner Naranjo violated the Open Meetings Act when he made this decision. The reference in the Recall Act to the conduct is to the wrongful conduct that supports the recall effort. So in this particular instance, it would be the Open Meetings Act violation, which was the decision.
But it must be a discretionary act.
Right.
Okay, so let's just answer this question for me. Is violation of OMA, assuming a violation in the theoretical, is a violation of OMA a discretionary act?
I don't know that Doña Ana County Clerk versus Martinez, which is sort of the seminal case that set that out. I don't know that they addressed that. And I think because the way that the Open Meetings Act was allegedly violated in that case was evidence of a corrupt or improper motive, just based on kind of the actions that were taken and the way that they just disregarded any concern to the contrary. I think that was a fair logical leap for the district court in that case to have said, okay, you guys have a rolling quorum. We've told you several times that you're violating the act and you keep doing it and you have no regard for anybody sort of calling that to your attention. You've ignored our letters. I think that's a fair leap. We don't have that here. All we have is a bare finding that Commissioner Naranjo violated the Open Meetings Act, from which no motive can be implied. I understand the district court's finding was, well, you can infer that he had an improper motive because he was trying to hide this decision from public scrutiny. But that's not an inference that's supported by any evidence in the record. And that's what the act requires. And we just don't get there on this record. To your question, Justice Vargas, about what would this look like, remanding it to have the district court clarify its findings, you get one bite at the apple for these Recall Act matters. The statute specifically says that there can only be one recall petition filed against an elected official during their term of office. And so the system is designed in a recall context to allow repeated attempts to cure a failure of proof or a failure of pleading. And again, I think that's a feature, not a bug, because there will be an election, there will be another election, and that will sort out the political aspects of this in terms of whose views on this issue are supported by the voters. So I think that that's the idea of having the district court sort of clean up its findings is not contemplated by the act. As to whether the specific evidentiary findings that the district court made with regard to Commissioner Naranjo acting, as Justice Zamora has pointed out, the only evidence that the district court really had and really relied on was that statement that he made at the August 29th meeting where he announced that that decision had been made. But again, under Paragon Foundation, even if we accept that as sufficient probable cause or sufficient proof, if he acted outside of the board's authority, then he's acting just like the executive director in Paragon Foundation did. The Open Meetings Act does not apply, and there's no Open Meetings Act violation. So for all those reasons, we would ask that this court reverse the district court. Thank you.
Thank you.
Kind of old school here, I got notes and whatnot, you know.
That's all right.
May it please the court, my name is Richard Rosenstock and I represent the petitioner in this case, Mr. Luis Pena Jr., who was substituted after the unfortunate passing of Antonio de Vargas. I'd like to be able to address the Paragon case by initially touching on what the case was about. There was no evidence, it was undisputed that this case involved a matter of significant cultural and social policy. It was undisputed that there were significant protests about the placing of the Oñate statute, first in Alcalde, and then after it was removed, when the proposition came up, the decision was made by the commission, as I'll explain, to move it to the front of the Rio Arriba County office building. That was undisputed evidence. And it was quite overwhelming. And it goes to why we believe the decision was made by the board in secret. Because it was obvious that there was substantial opposition. There were people who were for it too. That's not the issue. It may well have been if you had an open public meeting, everybody gets to hear what's going on. Maybe they usually have a public comment section. You get to talk. Maybe they would have decided the same thing. Not the question though, because that didn't happen. And there, as I've said, there was a reason why this was done in secret, quietly. And the second issue, of course, in an open meeting space can be whether it was made outside of an open public meeting. And obviously the question, the answer to that is yes. The issue is who made the decision, whether the board made the decision, including respondent, or county manager Maestas made the decision. That was the issue in front of the trial court.
Was it the issue, did you plead that that the quorum of the commission made the decision, or was it all focused on Mr. Naranjo?
It was focused on Mr. Naranjo because that's who the petition was seeking to have a recall election on. And the evidence presented, as I'm going to get to in about a minute, was overwhelming that the commission made the decision. It was completely overwhelming and really only contradicted by the
allegation was a malfeasance was his act. That's the issue we're struggling with.
his act.
There's, well. okay.
Because we weren't
Hold
seeking.
on. Let me finish my question. You allege his act was a malfeasance. And in order to show, and that is grounded in an OMA violation, and Paragon seems to require for you to ground it in an OMA violation, there must be proof and or an allegation that the body acted as a quorum, and that is absent in this case.
Well, I think there's an abundance of proof that the entire commission made the decision. And I was about to get to that, because that's what distinguishes it from Paragon, is the fact that the evidence here, and the court is entitled, I believe, under Rule 12-603 to affirm on whatever evidence, if there's evidence to support and uphold the trial court finding. And the evidence was, I would say, overwhelming. And I just want to run through it piece by piece. We start with the August 6th, the August 25th, 2023 email from Mr. Maestas to Ryan Martinez, who unfortunately ended up playing a very tragic role in this whole thing in regard to the shooting that occurred on September 28th. But this is exhibit number 6 at the trial. And in it, Mr. Maestas wrote, "The commission and I have decided that we definitely want to have the statute returned and are currently looking at relocating him in front of the county annex building." That's the county office building. Several days later, exhibit 8, minutes of the August 29th meeting, where the respondent and Commissioner Morales were present. So that was the quorum there. And respondent stated, "We will be erecting the Oñate statue. We would like to have that done within the next 30 days. Then we have exhibit 12. This was the email from County Manager Maestas, Sheriff Merrifield, and Under Sheriff Monica Salazar. And in it, September 14th, 2023 email, "I'm reaching out on behalf of Chairman Naranjo. The chairman is requesting assistance from the Rio Arriba Sheriff's Department to provide public safety for an event that will be taking place at the Rio Arriba County Annex Building on September 28th, 2023. The commission has made the decision to relocate the statue of Don Juan Oñate that was previously in Alcalde." Then there is the exhibit 14, which I think is, given the court's question.
So, Mr. Rosenstock, why aren't all the commissioners subject to recall? Why just Mr. Naranjo?
Oh, they were. And here's the reason why, as Mr. DeVargas communicated to me. Number one, there were other allegations in the petition that concerned solely respondent Naranjo. Number two, it was evident from these emails that of all the commissioners, He was the driving force behind this.
But isn't that for an OMA violation, there must be a quorum?
Yeah.
So
you don't.
hold on, let me finish the point. Thank you.
Thank
So there must be a quorum, and I think that is evident in the statute, may constitute malfeasance if the quorum of a county commission.
Yeah.
So it can't be almost accessory or liability theory. You need two individuals in a three-member commission. You're basically saying because one commissioner is making a decision that may or may not be unpopular, he may have been elected on the position of erecting the statue. He may have run on that platform, whatever that may have been. But in looking at the plain meaning of the statute, how can you only have one individual making the decision for a quorum?
The one individual didn't make the decision. The board made the decision. That's what all these emails said.
But
He's the
where in
only-
the complaint did you, or petition, did you allege that in the district court level? I understand what the record shows. I think the question is, what notice of this allegation that it was the entire commission is set forth in your petition below?
The petition was focused on the respondent. I think one of your honors mentioned that, I think Justice Bacon mentioned that. It was focused on the respondent. And all the evidence points to the board.
And there's
And
nothing in the
there's nothing-
statute that requires a recall petition to be filed against the entire board.
No.
The petitioner can pick whoever they want,
Of course.
as long
Yes.
as as long as there is established that there is a quorum that made the decision, and that individual subject to recall was part of the quorum that made the decision outside the
Of
open.
course, and I think it's important to note, I was going to get to the third reason that Mr. DeVargas had mentioned to me. Rio Arriba County is a big county, area-wide. It's the size of the state of Connecticut. You start looking at all three districts and having a recall, and each commissioner is elected by each district. You start looking at having to organize in each district to recall every single member. It's a really massive undertaking. And because what's in front of the court is not whether or not he should be recalled, it's simply whether a recall petition can be circulated to see if the signatures can be.
So I want to try and pin down two things. I think you've already answered the question of the petition itself didn't allege a quorum.
Right.
Where in Judge Ward's order does she find that there was a quorum?
She doesn't, but it was obvious that all the evidence was based on the decision.
But isn't that critical to a finding of a violation of the Open Meetings Act under Paragon, but actually just under the plain language of the Open Meetings Act, is that she needed to say there was a quorum, he was a part of that quorum, and they did not do it consistent with the Open Meetings Act, ergo malfeasance.
Obviously that would have been preferable because I wouldn't be facing these questions today had she done that. But the rule allows this court to decide to uphold the trial court on any basis that's in the record.
That's de novo. I mean, it is an interesting institutional question. We normally, I do understand that, but it's almost a de novo review on the record. I mean, normally we do our best to take the trial court at their word in their findings. We're not we're kind of right for any reason. We try and avoid that. So is your suggestion that we can just look at the full record and either interpret her order to say she meant the full commission, or we enter separate findings based on the record? Which is your request? Or is it remand?
Well,
To
remand is an option. I don't think it's the best option.
Okay.
But I think that this court can look at the evidence and determine whether that evidence supports the trial court finding. But I just wanted to focus.
There's no finding of
There's
a
no
quorum.
finding.
Excuse me, the trial court decision.
There's no finding of a quorum, so we would have to make that finding, correct?
That it was that's what would be reasonably inferred from the repeated emails that refer to the commission. And if I could, just Exhibit 14, which is an email from the county manager to Nicolas Gilmore, the New Mexican. He writes, "I will refer all questions to the county commissioners, plural, as this was a decision they made. Below is the contact information. Alex Naranjo, Brandon Bustos, Moises Morales. Then there was another email the following day to Natalie Wadis from KRQE, who wanted to know, and this was Exhibit 15, if Mr. Maestas would be available for an interview regarding the move, how it was decided upon. And he wrote back that day, I would refer you to the chairman of the commission, Alex Naranjo, to answer these questions. This was a decision that the commissioners made, and I think he could give you better answers on how this move was decided. There's no question that there was substantial evidence, overwhelming evidence, that the commissioners made this decision. And the judge was focused on what the petition asked for, whether there was probable cause that the respondent was involved in making that decision. We don't know the date that was done. It was done in secret. It appears it was certainly done before August 25th, before the county manager wrote Ryan Martinez and said, the commissioner and I have decided to put that statute up in front of the county office building. So it was made before then. It was made in secret. So we can't tell you where these people met and when they,
You could have at the trial court, and help me with the record if I have this incorrect. Similar to begin reading Paragon, called one other commissioner and said, did you have a conversation with another commissioner? That would be a quorum, as I understand, given this commission on this question. That would satisfy the proof. I know there's these inferences that all this was done, but the burden still falls on the petitioner to prove it, and it didn't seem an overwhelming obligation to do that.
well, I think the reasonable inference, which is that they're the commissioners, plural, that's what all the emails say. The commissioners made the decision. It was done in secret. How can we possibly know? They had the opportunity to call the respondent. He was in the courtroom. They didn't call him. They could have called the other commissioners to say, oh, the county manager's right. There was no quorum.
But ultimately, it's your client's burden, and you didn't ask the district court for a finding regarding the quorum.
Well, it seemed the evidence was that the commissioners, plural, had made the decision. And the judge was focused on what the petition was focused on. That was whether there was a basis to find that the respondent had violated the Open Meetings Act through his involvement in that decision. And I don't think Paragon is at all applicable because there was no evidence there that the commissioners, that the livestock board commissioners had made that decision. It was actually quite the opposite. They submitted evidence saying we didn't know about it. I think one or two of them said we were surprised to hear it. That wasn't the case here at all. It was, other than Maestas' testimony at the hearing, which with all due respect, I don't think any of you all would have found credible either, coming 7 months after.
So let me ask you something. Are you saying the only way we can find for your client is to make a determination that the district court judge was right for any reason?
Well, I think that's probably the most obvious way.
But isn't that generally limited to right for any legal reason as opposed to exploring the record and finding facts to support the conclusion that you're asking for?
I don't think you have to explore the record. I think the question is whether the court can draw reasonable inferences from the facts in evidence at the hearing. I would note too that.
Which is exploring the record.
Excuse me?
That's exploring the record. If we're going to
Well-
review in anew all of the evidence in the record or all the evidence submitted at the hearing, that's us giving you a significant do-over.
Well, I think if you're even just judging the evidence on a substantial evidence basis, you look at the evidence and you say, well, is that substantial evidence to support the finding? I think the judge did make on page 4 of her opinion, she noted that Commissioner Naranjo argues it could be no owner violation because the disposition of a piece of county property, the Oñate statute, is not a decision the commission was required to make. However, the nature of the act determines whether it's subject to OMA. And then she goes on to say why this was a matter of public policy. I think the court implicitly addressed the role of the commission and focused on the person who was the subject of the petition. It actually wouldn't have made a lot of sense in a way to be focusing elsewhere, given the nature of this particular type of proceeding. So I think that the case is distinguishable, obviously distinguishable from Patagon, because there was undisputed, and I think as Ms. Rogers said, even the plaintiff said the commissioners had no involvement. The board had no involvement, rather. Here the evidence is the board made the decision. Respondent was a member of the board, and he was the individual who was the contact person after in these emails, along with actually 14, all three of the commissioners. Here's the contact information for the commissioners. They made the decision. Contact them if you have any questions. I think, to me, it's pretty clear that the evidence here supports the trial court's conclusions on the Open Meetings Act. And I'd just like to take some more questions. I don't feel I need my 30 minutes for this because I think the evidence was overwhelming, and the court will decide on this other question that's been raised, whether it's a remand or so I'd like to take some questions.
There's one area I'd appreciate your view on, given, you know, there's not a whole lot of writing in this area. Is the Doñana case? Are you prepared to discuss that case?
Yeah, I can discuss that case.
I'm troubled by some of the requirements in Doñana with regard to what seems to be alleged that there must be, with regard to an OMA violation in particular, some kind of improper motive, that whether it's a discretionary act, non-discretionary act. That's my first question.
Okay.
The second is it seems to imply there must be a pattern, a number of, and maybe that's just my reading of it, but multiple intentional acts. Do you see that requirement coming out?
No, that really doesn't make, I don't see that as a requirement. I think that was what was involved in that particular case. But you could have an OMA violation on a really significant matter of public policy. And I don't think the burden would be on the plaintiffs.
Is there any requirement of intent?
Well, I think that it's a mandatory act, but to the extent that there is, and Judge Ward addressed that. She did address that. And I think there's substantial, overwhelming evidence again. Let's start with the changing stories by the county.
But that doesn't answer the legal question that the Chief Justice is asking
In
you.
regard to motive intent or in regard to?
Motive intent, is that a requirement?
Well, what I'm trying to say is that I don't think it is a requirement, but to the extent that it is, Judge Ward addressed it. And she laid out the facts that she felt.
I accept your point on that. So let me go back to, there is no requirement. It is a non-discretionary act. Therefore, it can form the basis of a recall petition without the specific intent. If that is true, if that is the rule you're asking for, what would a county commissioner do, mostly lay people who rely on general counsel to give them advice? I need to move this piece of property X. General counsel says you don't need to, but it ends up being a trial court finds it's an OMA violation. Is that significant to trigger a recall? It's concerning to me on the other side that you know, these are lay folks generally, and if they're given advice that they don't need to do this.
That's a good question. I like that question. And I think that,
Appreciate that.
I think that it would be, I think that if that was the situation, that would be something that would need to be discussed here. If there was evidence that the county attorney had advised the commission that this was okay to do, certainly, you know, it's a good defense in a civil case that advice of counsel. In this case, it could be a defense to I'm not sure it would be, but it's not the situation we have here. But there's a lot of evidence of motive and intent here on the part of the respondent. And I can go through with it if you want. And I'm happy to do that because I wrote it down on my piece of paper as a bunch of notes. But one of the things I did want to point out is that the U.S. Supreme Court, and this court is, I think, cited to that case in some of the Human Rights Act cases, Reeves versus Sanderson Plumbing, where the Supreme Court of the United States said that finding that an explanation for an action is unworthy of credence allows the trier of fact to reasonably infer that an improper motive was the real reason. And that's Hornbook law in regard to motive and intent cases involving discrimination or retaliation, and it just makes sense. And so that was a huge piece of evidence that supports improper motive and intent, is the finding that the changing story of Mr. Maestas was not credible. And it clearly was a changing story from his contemporaneous statements at the time.
So I guess I don't quite understand, because that's where I'm struggling. It requires improper or corrupt motive pursuant to the Mexico Constitution. I mean, these are loaded words. These are important in terms of there has to be a level of wrongdoing.
Yeah,
So
well, if we,
hold on, no need to apologize.
a little bit anxious here, Your Honor.
Understood. So, but what is pointing to the record that there was a corrupt motive or improper motive that rises to a level of malfeasance?
Well, the motive was to conceal, the improper motive was to conceal the decision from the public. That's what was the improper motive. And that's why there was this changing story by the manager at the hearing from what he had said contemporaneously. After things happened, after this decision was made, one, there was the shooting where somebody was seriously injured on that site. Number two, there was the filing of this petition, which is probably a bigger impetus for the changing testimony, because at that point, it became important in order to provide cover for the respondent, for the county manager to say, the commission didn't do this, I did it by myself. And that's what the motive, the improper motive was, to conceal. That's what the Open Meetings Act was about.
But there was this, I mean, I'm looking at this and taking out the historical aspect of the statute itself. Let's put that aside. And if we treat this as simple a work of art, and we're going to simply move county property from one position to another. If we have a retablo from the Santuario de Chimayo, we're going to display it in one part of the, county government building and to put it in another part. Is that a corrupt, is that an improper, is that an improper motive?
No, because it didn't involve a matter of important social and cultural public policy that the public would be interested in. There would be nothing wrong with that. It'd be like moving a swing set from one county park to the other. There's nothing wrong with that. The disposition of county property does lie in the hands of the county commission under statute, but whether or not it rises to the matter of public policy, the example Your Honor gave, I would say, does not, to move the painting from one county building to the other. But this was a whole different kettle of fish. This was, in a matter of public policy, a big deal. And we saw what happened down in Albuquerque over this statute, unfortunately, back in 2020. These statutes and whatnot have become a major matter of public policy throughout the country over the last 4 or 5 years, whether it's the Oñate statute in Española or in Albuquerque, or the De Vargas statute and the runner statute.
So because our elected officials take on a controversial policy or a controversial decision that may be important to some of their constituents, or maybe a majority of the constituents, they're going to be subject to a recall because it is,
if they violate, if they hold a secret meeting to deal with the matter, the Open Meetings Act expressly says that matters of public policy have to be discussed in an open public meeting. And yes, if you violate that, you're subject to a recall if the people in your district wanted to do that.
Can I move you just in a slightly different direction?
Absolutely, Your Honor.
Thank you. You obviously agree that there was no finding of a quorum by the district court judge and the petition had no allegation of a quorum. Assuming we find that fatal to your claim, what do you expect to happen on remand? I mean, why wouldn't it just be reverse and remand? What would you anticipate? Or are you suggesting that we'd remand for another hearing?
Well, I'm not suggesting you remand for another hearing, but if the court feels that there needs to be a specific finding by Judge Ward, then yes, but I really don't think that's required, but it is an option.
But doesn't that give you a second bite at the apple, so to speak? If you
No,
just-
it gives her the chance to clarify what she did.
Thank you.
Any other questions?
No other questions. Thank you, counsel.
Thank you. Appreciate the opportunity to be here. It's been a while since in front of the court here.
It's nice to see you. All right. Ms. Rogers, 5 minutes.
Thank you, Chief Justice. You triggered something in my thought process with regard to Doña Ana County Clerk as it pertains to the Open Meetings Act violation. The Open Meetings Act on its face allows a cure, and it contemplates that if a body is notified that they violated the Open Meetings Act, they have a certain amount of time to fix it, and they're allowed to do that. They can essentially get a mulligan if they are notified that they violated the act, okay? That also in conjunction with the fact that it's sort of self-executing like you saw in Paragon. What the court there said was, well, this isn't a valid act. And in that way, the Open Meetings Act is sort of self-executing, meaning that if an action is taken in violation of the act, it's not a legally valid or legally binding action. So because of that, there has to be other evidence beyond the bare Open Meetings Act violation of an improper or corrupt motive. There has to be. Otherwise, that language would just be surplusage at that point. It can't just be the bare fact of the violation of the Open Meetings Act. There has to be other evidence of an improper or a corrupt motive. And what happened in Doña Ana County Clerk that you reminded me, Chief Justice, was that they were sent at least 2 letters saying you guys are violating the Open Meetings Act. And you are doing it because you're engaging in these rolling quorums and these other issues, and they ignored that. And that was evidence that the district court was able to look at and say, okay, we've got a situation here where they've been told about this, they know about it, they're aware of it, and they are doing what they want to do regardless. That is not a terribly significant logical leap for the district court to have made. What we have here is a bare finding that Commissioner Naranjo, again, Commissioner Naranjo, not the Board of County Commissioners of Rio Arriba County, violated the Open Meetings Act. And then there's just an inference supported by no record evidence that that somehow is an improper or a corrupt motive. But more is required under the statute and under Doña Ana County Clerk. I disagree with Mr. Rosenstock's characterization that the evidence that this was a board decision was overwhelming. It was non-existent, other than those 3 emails.
But that's significant. The manager testifies, no, I made this decision all by myself, and that is absolutely contradicted by his own words in writing.
Yes.
Where he says, not so subtly, I mean, it's overt. He says, the commission made this decision. If you have questions, ask the commission because they made the decision. This was a decision of the commission. That's pretty damning evidence. So I minimizing that, I don't think is terribly forthright at this point.
And I'm not attempting to minimize it. What I'm saying is that in the context of what happened, he said, the reason I did that is because I was new to the role. We were getting all this media attention and all these media inquiries. So I essentially punted to the commission. In a couple emails, he said it was a commission decision.
But remember, Judge Ward said he's not truthful. That was her finding.
It was. And it
Because
was.
it's contradicted by everything he put in writing.
But now
He didn't believe the story. So we can rely on the documents, not on anything he said.
And if you do rely on the documents, Justice Bacon, what you've got is at best equivocal statements by the county manager that maybe it was the commission, maybe
Oh,
it was Commissioner
there's nothing
Naranjo.
equivocal about the words in those documents.
But the who is the important part here, Justice Bacon. Who made the decision? Some of those emails say it was Commissioner Naranjo. Some of them say it was the commission. That's equivocal at best. That does not rise to the level of.
We only have,
probable
the
cause.
burden is only probable cause, right?
That's not even, doesn't even get you there. It has to be more likely than not. And you can't even get there with that evidence. You have some equivocal emails by a third party who's under duress by his own testimony at that point. That's not enough to support a finding that the board acted. And the district court didn't make that finding. And that's what's fatal to the petitioner's position before this court. There was no finding about the board. Even if this court were to uphold the finding related to Commissioner Naranjo, he can't violate the Open Meetings Act by himself. And for those reasons, the appropriate remedy is reverse and remand with instructions to dismiss the petition.
Counsel, can I ask you one question before you sit down?
Of course.
Am I correct, and my memory may be failing me, but is there not a provision in the Open Meetings Act that provides that there's a presumption that whatever body we're talking about has complied with the Open Meetings Act unless there's evidence that they have not? I'm thinking it's in section 3.
Yes.
Do you recall that?
Yes.
And how does that fit into all of this?
Again, I think it's important just to consider the procedural footing. At the district court, the argument wasn't the board took these actions. The argument was Commissioner Naranjo went rogue and made this decision all on his own. The evidence at best is those emails. That's the best evidence. The board, there's no dispute, took no action that we can look at meeting minutes, for example, and say, hey, look, there's an official action of the board with regard to this statute. So there was no board action, and certainly not any board action by a quorum. And because of that, the Open Meetings Act is inapplicable to these facts.
Thank you.
Thank you.
Thank you, counsel, for your presentation and your briefing in this case. S-1-SC-40411, Pena versus Naranjo is now deemed submitted. The court is in recess until 1:30.